Dr. Deepanjan, can you hear me?
Yes, I can hear you, Dr. Kumar. Am I audible?
Yeah. Whether we can start the meeting?
Yes, we can start.
Okay.
A warm good morning to everyone present here. On behalf of the Legal Center of History of South India of Tamil Nadu National Law University, in collaboration with the VIT AP School of Social Sciences and Humanities, VIT AP University in Amaravati, Andhra Pradesh, I welcome you all to commemorate the 75th year of the Indian Constitution, where we are organizing a two-day national conference on the legal professionals in the Indian freedom struggle. I warmly extend greetings to everyone who is here. I hope you will join us for the next 2 days, listen to all of our panel speakers, technical session speakers, and plenary speakers, and have a fruitful learning experience with an abundance of enlightening perspectives. To start off the inaugural program, some brief ground rules. If possible, please do keep your videos on and encourage the speakers who will be presenting today and everyone who is here to give us insightful experiences. And along with that, please keep yourself on mute so we do not disturb the speakers who take the platform as well. Before we begin our inaugural program, I would like to invite Dr. P. Kumar, the Assistant Professor of History of Tamil Nadu National Law University, and our faculty in charge of the Legal Center of History of South India, to give us a brief introduction about the two-day national conference, which is about to commemorate.
Thank you, Ms. Nega Bharati. Respected Vice Chancellor and Registrar of the Tamil Nadu National Law University, Tiruchirappalli, Tamil Nadu. Respected Vice Chancellor, Registrar of the VIT AP School, AP University, Amaravati, Andhra Pradesh. Respected resource persons of the inaugural session, paper presenters and observers, faculty colleagues, legal professionals, research scholars, and student friends. Very good morning to you all. My name is Dr. P. Kumar, Assistant Professor of History and the faculty in charge of the Legal Center for History of South India, Tamil Nadu National Law University, Tiruchirappalli, Tamil Nadu. So the center is one of the 15 research centers in the university, established in the year 2021 with the financial support of the government of Tamil Nadu to promote the knowledge of the legal history of South India. There are 20 student members associated with the center, and they play very important role in the center's activities. In the last 3 years, we have organized 9 events such as conferences, seminars, invited talks for this purpose. A few months ago, we brought out a publication based on a minor research carried out by the center about the Tamil members who had contributed to the formation of Indian Constitution. So the idea of organizing this two-day conference on legal professionals in the Indian freedom struggle was simply a result of a monthly meeting of the center that took place in last August. The idea was further shaped by my friend, Dr. Deepanjan, Assistant Professor at the VIT AP University, Amaravati, Andhra Pradesh, when I contacted him for collaboration. The idea was put into action with the patronization and administrative support of the vice chancellors and the registrars of both universities. The resource persons and the paper presenters of this conference also contributed immensely. With these few words, let me conclude now. Thank you.
Thank you, sir. In continuation, I would like to invite Professor Dr. S.M. Balakrishnan, the Registrar of our Tamil Nadu National Law University, to give us the welcome speech today.
Thank you, Ms. Sneha Bharati. Vanakkam. Hearty welcome to all of the panel members, to all the members here who have assembled here for this two-day national conference on legal professionals in Indian freedom struggle. It is indeed the need of the hour, actually. So to have a trickle-down effect on the next generation there. So what are the who are the legal professions who actually fought for the freedom struggle. There were persons from different the nationalist struggles, nationalist freedom struggle there, the freedom struggle by the Hindu Mahasabha and others, the freedom struggle by the Dravidian movements here, and all these things will be having a trickling effect to the next generation there. Uh, on behalf of the Tamil Nadu National Law University family, I would like to welcome our Honorable Vice Chancellor Professor Dr. B. Nagaraj in absentia. Warm welcome to this conference, sir. And I would also like to welcome the Honorable Vice Chancellor of VIT AP University, Professor Dr. S.V. Kota Reddy. Thank you so much, sir, for being here. A warm welcome to the conference, sir. And I would also like to welcome the Registrar of the VIT AP University. Thank you so much, sir, for joining us. And our own Professor Dr. Rajendran sir is actually very close to association with our university. Sir. Thank you so much for being here, sir. Warm welcome to Tamil Nadu National Law University, sir, for inaugurating this conference. We'll be extremely happy to hear from you the words of wisdom. Thank you so much, sir. And I would also like to welcome Professor Mithi Mukherjee, Associate Professor from University of Colorado. Thank you so much, ma'am, for being here. I'm sure that will be we was there in the United States at this time. But thank you so much for joining us and a warm welcome to this national conference, ma'am. And I also like to welcome the Dr. Priyanka Ghosh. Dr. Priyanka Ghosh, the Dean in charge of VIT AP School Social Science, will be delivering the vote of thanks. And a special thanks and congratulations to Dr. Kumar sir and Dr. Deepanjan sir for organizing such a wonderful conference there. I'm damn sure the next 2 days will be having a lot of new information there, especially about the lesser known legal professions of the freedom struggle movement there. Because we know about the freedom struggle movement, we know a little bit about the freedom struggle movement there, the Congress leaders there. What about the other lesser known freedoms in various parts of India there? So this conference will be throwing light on all those aspects there. So I'm as a as a student of law, as a student of history, it will be great pleasure for me to hear from all these persons, the wisdoms there, and a warm welcome to all the paper presenters there, because without them this event wouldn't have been possible there. I've received a lot of wonderful papers there, and we are so happy to hear from these young talented students and young assistant professors and various universities on hearing these on the matters relating to the conference theme. And also like to welcome all the my student friends of Tamil Nadu National Law University as well as from students friends of VIT University, bridging so these latest technologies has bridged the gap. So just by sitting in the cozy of your room, we can hear people from various parts of India talking in various parts of even foreign countries. Their professor has joined from United States of America. So once again, I would like to welcome each and everyone to this event there. I hope the next 2 days will be very enriching and rewarding experience for each and every one of you. Not only for the students, even for all the professors, even for the persons like me. So it will be a very enriching, rewarding experience, and hope for the next 2 days will bring lot of cheers to us. We can take lot of the takeaways will be very great. Very much new information will be getting there. So I'm looking forward to this conference. And once again, on behalf of the Tamil Nadu National Law University family, a warm welcome to each and everyone. அனைவருக்கும் வணக்கம். Thank you so much.
Thank you so much, sir. We're so grateful to have you here as well. Next, I would like to call upon Dr. S.V. Kota Reddy, the Vice Chancellor of VIT AP University, for the opening remarks to the inaugural program.
Good morning, everyone. Respected Professor Dr. S.M. Balakrishnan, Registrar Tamil Nadu National Law University, Professor N. Rajendran, former Vice Chancellor, Algappa University, Karaikudi, Professor Mithi Mukherjee, Associate Professor of History, University of Colorado, Boulder, USA, Dr. Priyanka Ghosh, Dean in Charge, VIT AP School of Social Science and Humanities, Dr. Ravi, Dr. V. Rajesh, the convener for this conference, and other people, like Deepanjan and our faculty members, and all the participants, these keynote speakers. A warm welcome to each one of you to this national conference on legal professionals in Indian freedom struggle. This conference is being organized in collaboration with the Legal Center for History of South India, Tamil Nadu National Law University, Tiruchirappalli, and VITAP University. And I'm very happy that the Tamil Nadu National Law University came forward to collaborate with us on this conference, because in fact the request came from them. Immediately we accepted it, and I would like to commend the efforts of both the sides, like the conveners from Tamil Nadu National Law University as well as conveners from our VITAP University to have this collaboration to organize this conference. Actually, the topic is very interesting. Basically, the legal professionals in Indian freedom struggle. Then those days, actually, there were many lawyers participated in the freedom struggle, and the legal professionals who actually participated in the freedom struggle in this conference. I mean, we should know what contributions they have done, what sacrifices they have done during the freedom struggle. Then this is actually the very apt, because now we are celebrating the 75th year of the Indian Constitution. Then in that context, we are organizing this conference. I am very happy. And about VITAP University, what we are doing at our university is that we encourage all the schools. We have 7 schools: School of Computer Science and Engineering, School of Electronics Engineering, School of Mechanical Engineering, and School of Social Science and Humanities, School of Law, School of Business, and School of Advanced Sciences. All these 7 schools, we are encouraging them to organize the international conferences. Basically, the international conference as well as national conference of very important kind of this kind of conferences. See, basically, these conferences will enhance our research output, and also enhance the knowledge of our scholars, faculty members, and students. And this kind of conferences will provide the platform for researchers to share their findings, and that way the enhancement of research output also will be there. So therefore, we are encouraging all the schools to organize this conference. Now, a recent trend is that we are organizing the international conferences in collaboration with some of the prominent international universities, and most of the universities from USA, then UK, Australia. We are actually collaborating with them and then organizing the international conferences. And those conferences also are giving the platform at international level, and we always encourage them to, our research scholars, faculty members, and students to participate in those conferences and publish the papers. And some of the papers are getting published in the Scopus Index journals, and we provide the funding also for social sciences research. We provide the funding. We have various funding schemes, internal seed grants, and this kind of the research in history also. We are providing the funding for gathering the data and then analyzing the data. Then and also we are getting the external grants, particularly in social science and humanities. Also, we are getting the external grants from various government agencies. And with all these efforts, with internal grants and as well as external grants, our publications in Scopus Index journals have gone up significantly. And since inception 2017, we published more than 4,000 papers in the Scopus Index journals. And the last 2 years, particularly, the numbers have gone up. And that way, we are actually contributing towards research at the university. Then apart from this, we work on the innovation side also, innovation and incubation side also. And we encourage our faculty members, research scholars, and students get into the innovation projects, and then getting into the patent publications. We published more than 560 patents in last 3 years, and this is actually quite significant number. As emerging university, we are number 1 in the country. And also, we are actually the fastest growing university in the country. 2017, we started with the 600 students, and today we have 17,000 students. and all the schools are contributing towards the research and innovation side. And with all these efforts, the VITAP University ranked number one under emerging state private universities in 2022, 2023, as well as 2024. 3 consecutive years, we are number one in the country under emerging state private universities category, and this is out. This is as per the Outlook ranking. Now we are in the process of getting into the NAC accreditation and other the QS rankings, etc. We are going to participate, and this is what actually we are progressing towards that. For all these things, the parent campus, our BIT Vellore, we are following the footsteps of them, and then also we are actually, I mean, for all these things, there is the support from the leadership, particularly from our management, our Honorable Chancellor, Dr. G. Vishwanathan sir, and Dr. G.V. Selvam sir, Sri Shankar Vishwanathan sir, Dr. Shekhar Vishwanathan sir. All these, our vice presidents are supporting immensely for the progress of this university. I would like to thank them on this occasion. And before I conclude, I would like to once again thank the Tamil Nadu National Law University to organize this conference in collaboration with VITAP University. And also, I would like to appreciate the efforts of our faculty members and the Dean in charge, Dr. Priyanka Ghosh, and the conveners to organize this conference. Once again, I appreciate all the efforts of each and every one. And I wish all the very best. This conference should give the greater knowledge and also create new knowledge for all the participants. I wish you all the very best. Thank you. Thank you all.
Thank you so much, sir. We're so happy to be in collaboration with your esteemed university. Next, we have Professor N. Rajendran, the former Vice Chancellor of Alagappa University, Karaikudi, for the inaugural address. Professor N. Rajendran has a PhD in Modern History and National Movement from the University of Madras. He has over 10 years of experience as the Department of History Head of Bharathidasan University, Tiruchirappalli, and is the founder director of Bharathidasan School of Management in Tiruchi. He has published many research papers, articles, and books, which run over hundreds in numbers. But namely, one of his books, Nationalism and Swadeshism in Tamil Nadu, which was written in Tamil in 2003, was given the Best Book Award by the Collector of Tiruchi. He has immense knowledge on the subject matter of this conference, and I welcome him now to give the inaugural address for the same.
Thank you, Dr. Sembaka Bharati. I hope I'm audible to you.
Yes, sir.
Thank you. Learned Professor V. Nagaraj, Vice Chancellor of Tamil Nadu National Law University in absentia. Learned Professor S.V. Kota Reddy, Vice Chancellor of VIT Andhra Pradesh. Respected Registrar S.M. Balakrishnan of Tamil Nadu National Law University. And distinguished panelists, Professor Mithi Mukherjee of Colorado University, USA, and Priyanka Ghosh, Dr. Priyanka Ghosh, Dr. Kumar, and very distinguished panelists of this 2 days national seminar, scholars, faculty, ladies and gentlemen. In fact, it gives me immense pleasure to be here this morning to share some of my ideas with you. In fact, there is a vast literature available on national movement. And if you search for the role of legal professionals in the freedom movement among this literature, I might say you may not find very much on this subject. The Tamil Nadu National Law University's effort in this direction is the need of the hour. I really appreciate the Vice Chancellor, the Registrar, and as well as the collaborating university, VIT Vice Chancellor, Registrar, and of course, the organizing faculty members. The process of colonization and decolonization of the modern history of Afro-Asian countries dominates the discourse on nationalism and anti-colonial studies. When Adam Smith wrote his magnum opus, Wealth of Nation, seldom he would have realized the consequences of free trade and laissez-faire. In fact, it has opened up the consequences of imperialism and colonialism in Asia, Africa, and Latin America. Of course, this is one view. There is also another view. You have John Fairbank, the editor of Cambridge History of China. He says it is the backwardness of Europe, particularly economic backwardness as well as cultural backwardness, which drove the European countries towards the east. And India was colonized by Portuguese to start with, and the French, English. There were also the Dutch settlements and Danish settlements, in due course seized by, of course, the French or the English. The Indian anti-colonial struggle mainly centers around the British colonial possessions. In fact, when we achieved independence in 1947, there were enclaves. In fact, there were 566 or 52 princely states, and also you have the French enclave and the Portuguese, and of course the major chunk was, of course, the British India, as we call it, and it comprises of nearly 85% of the undivided India. So the Indian anti-colonial struggle mainly centers around British colonial possessions. The often used nomenclatures of these anti-colonial struggles are revolts and mutiny, either by rulers or sepoys, freedom movement and national movement. Sometimes these are used in an overlapping way, but I think the august audience know very well that they cannot be used in such a manner. Often used a nomenclature, the anti-colonial struggle, in fact, starts with the Polygary revolts in the late 18th century in deep south in Tamil Nadu. Similarly, the Mysore wars of Hyder and Tipu and the Carnatic wars, ultimately culminating in the Battle of Plassey in 1757, which entrenched the East India Company in India, both politically as well as economically. There was also the mutiny of the sepoys. The well-known mutinies, of course, are the 1806 Vellore Mutiny and the great Indian Revolt of 1857, which Veer Savarkar terms as Indian War of Independence, which was denied by, of course, R.C. Majumdar. But the history of anti-colonial struggles bypass several mutinies. There are several mutinies like 9th Battalion in 1775 under the control of Captain Kelly, which was stationed in Tiruchirappalli, but it was ordered to go to Bombay via Travancore. On its way to Travancore at Kovilpatti, the 9th Battalion rebelled. Of course, the rebels were blown off from the mouth of the gun. And similarly, the 35th Battalion, which was under the control of Captain Kenny in Ceylon, both regiments were from the Madras Army. This again gives a perspective. In the sense, this also breaks the myth that Madras Army was loyal to the British and no significant mutiny took place before 1806, that is Vellore Mutiny. Similarly, several uprisings of the tribals and peasants have gone unnoticed. But today, efforts are being made to place such revolts in proper perspective. Particularly, this seminar is one such venture. There is vast discourse available on Indian freedom movement at the national and regional level. Most of the stalwarts of national movement were from legal background, specifically lawyers trained in England. If you ask a question of any student of history, what was the contribution of legal professionals in the Indian freedom movement, the answer may not be well articulated. If the same person is asked to describe the role of Mahatma Gandhi, Sardar Patel, Bala Gangadhar Tilak, Lala Lajpat Rai, or Jawaharlal Nehru, there will be an outpour of facts and figures of the individuals. Hence, the topic of this national seminar is vindicated and justified. And what is the character of this movement after 1857 revolt? Participation of the Indian intelligentsia, mainly legal professionals, into the mainstream of the freedom movement. This gave people a platform to discuss and share their grievances and in turn devise a plan of action. This was the first time that Indians realized that violence was not the only means of fighting a battle, and in the years to come, the tools like Ahimsa and Satyagraha would become the two pillars on which the freedom struggle rests. The war against British was not a war of arms, but a war of strategy and mental strength. Most of it was a war of words. Who better to fight such a war but the magician of words, those who have words for tools, namely the lawyers? It is said in good context anyway. The Indian freedom fighters, actually, they were from the, say, legal background. They were army of lawyers who used words for ammunitions. Mahatma Gandhi was a lawyer, so was Motilal Nehru. C.R. Das, Pandit Nehru, Sardar Patel, and Dr. Rajendra Prasad, to mention a few. The list is long but never ending. This rich, at the same time, what is the position of the other classes? The rich were too busy fixing the future of India with the British, and the poor were too poor securing 2 square meals a day and forget about a rebellion against the mighty British Empire. This was the time when the educated middle class came to the fore. They constituted lawyers, teachers, doctors, civil servants, etc. The proceedings of the British government during this period reveal that the government took notice of the phenomenal and preponderance role played by the legal professionals in national. I have gone through certain records in the Chennai archives where often a question is asked why there is a large number of lawyers participating in the, they don't say national movement, but say political agitations. There were disparaging comments also from the government regarding the participation of the lawyers. They were attributed to the lack of jobs, no other option but to get into freedom movement. These are the comments passed by the bureaucracy for the question raised why lawyers were participating in large numbers in the freedom movement. The statement is non-tenable in the case of Gandhiji, Motilal Nehru, the richest lawyer, and Vivo Chidambaram Pillai, because all of them had, I must say, if they practiced well, leave alone Motilal Nehru, who practiced law and who became very rich because of his law practice. Vivo Chidambaram Pillai again, he threw everything away and joined the cause of the Swadeshi movement to pitch the native capital against the European capital. What are the reasons for lawyers' participation in the freedom movement? First of all, lawyers were not government employees, unlike the teachers, doctors, civil servants. So there was no obligation to follow directions from the government. Secondly, if lawyers could boycott courts, it would be directly defying the British government and law. And in turn, it would directly imply that the rest of the population were not obliged to follow these laws. Thirdly, most of the lawyers had studied in England and they were aware of the English legal system and of the position people had in an independent nation. Also, they knew how to talk their way through the English. Lastly, they knew their weakness and strength and could successfully devise a way to play the weakness of the British to their advantage. That is the lawyer's advantage. And the most important thing is what was the concept of nation and India, oblique India, before 1985 and after 1885. Before 1885, the concept of nation oblique India was conspicuous by its absence, as characterized by Eurocentric epistemology, because there was no nation as such. The imperial historiography characterized this notion. For instance, James Mill, The History of British India in 3 volumes, where James Mill painted India, pre-British India, in dark colors. Of course, he has used Jeremy Bentham's utilitarian philosophy to justify the British rule in India. And here, the official documents concretized the notion of India and in their correspondence and dispatches. In 1885, the establishment of Indian National Congress, this INC, concretized the idea of nation and India, because the very title carried, for the first time, India and nation. In 1905, Dadabhai Nauroji, one of the lawyers, in fact, the great grand old man of India, described this process as India is in the making. So the early phase of the national movement had very distinguished legal professionals. And this phase was characterized by terms like moderate era. But John McLean of Princeton University titled his work of this period as Indian Nationalism and Early Congress as against Daniel Argov book Moderates and Extremists in the Indian National Movement, 1883-1920. This is again a kind of an epistemological barrier to understand and use the use of the colonial terms to describe the role of the Indian nationals in national movement itself. Dadabhai Nauroji, known as the grand old man, as I said earlier, he was a lawyer of one of the founding members of the Indian National Congress too. And he highlighted the economic exploitation of India under the British rule and his pioneering work on British rule in India on the economic interpretation of the British colonialism expounds the poverty theory and drain theory. Now, this impact, the impact of Dadabhai Nauroji's work on Indian mind could be seen from the circulars sent from the headquarters or central government to the provincial governments. So they said they objected particularly what should be taught in history and economics in the colleges and higher education institutions. Particularly the idea of nationalism should not be taught in the higher education institutions because it is irrelevant, particularly German nationalism and Italian nationalism. Similarly, in economics, the drain theory of Dadabhai Nauroji should not be taught. Instead, they said, and you must teach the citizen of India, and that is best suited book for the Indian students to read and appreciate the work of the British Raj. And you had luminaries during this period: Gopalakrishna Gokhale, Parasho Mehta, W.C. Banerjee, Surendranath Banerjee, Raj Bihari Ghosh. But the next phase witnessed Balagangadhar Tilak, who gave Indian national movement a new direction. A new radical phase of thoughts and ideologies were introduced in freedom, advocated stronger actions like Swadeshi, boycott, and Swaraj. And he said, Swaraj is my birthright and I shall have it. And this was known as passive resistance because this term was coined by Aurobindo Ghosh. In his articles in well-known daily, English daily, Bande Matra, Balagangadhar Tilak was imprisoned after his participation and deported to Mandle for 6 years, during which period he wrote Geet Ragasya. In fact, Geet Ragasya was a commentary on the Bhagavad Gita, but Tilak used Gita's teachings to inspire Indians to actively participate in the freedom struggle, aligning spiritual duty with national service. It is a theoretical perspective of the lawyer turned freedom fighter. Similarly, another legal luminary, Lala Lajpat Rai, who constituted the triumvirate, Lal, Bal, and Pal, presided over the first session of All India Trade Union Congress in the year 1920. He also attended Geneva 8th International Labour Conference in 1926 as a representative of Indian laborers. Similarly, the theoretical part of the freedom struggle was again we can find in Hind Swaraj. Hind Swaraj is a magnum opus and the first book of Mahatma Gandhi. Gandhi, while he was traveling from London to South Africa in 1909, wrote this book in Gujarat and Gujarati language. In 1910, this book was banned by the British government. And in fact, it is a blueprint for Indian self-rule and the tools of fighting the British. It was a critique of modern civilization and the vision of Swaraj. And he said Swaraj is not just political independence, but self-rule in every aspect of life. Similarly, Swadeshi, he said Gandhiji's advocates for economic self-sufficiency through the promotion of local industries and rejection of foreign goods. And even before the launch of the Swadeshi movement in 1905, this happened. Criticism of British rule, he criticized British colonial system for exploiting India and disrupting Indian traditional way of life. And of course, the most important thing is he devised methods to fight against the British, non-violence and passive resistance, that is satyagraha and non-violent resistance. Of course, this book is the cornerstone of Indian Gandhian philosophy, which was a theoretical component of Gandhi way back in 1909, well before he landed in India in 1915 and carried out his struggles in India. And in fact, in 2 years' time, 1917, 1918, Champaran Kaida Satyagraha, Ahmedabad mill workers strike, within 2 years, he successfully rallied two most significant subaltern groups, namely the peasants and laboring class, under his leadership. And this was followed by non-cooperation, civil disobedience, and the Quit India movement. Now, I would like to just upon Salt Satyagraha, which is a magnum opus, I would say, because salt was a marches always turned the course of history. And we have read that Moses led the Jews to the promising land, splitting the Red Sea. Similarly, Mao said all long marches begin with a small step. And in fact, Gandhiji started this march on 12th of March with 78 followers from Sabramati Ashram to Dandin, and he was arrested, of course. And he crossed through 5,000 villages, and nearly more than 1 lakh of people participated and witnessed this march. And that year, the Times magazine, which is published from London, carried the photograph in the first page of Mahatma Gandhi, because the significance of the march is such. And again, we have the lawyers defending the freedom fighters. When the partition of Bengal was announced, there was an enormous upsurge in Bengal. And of course, quickly it spread to other parts of India. And there were also violent incidents. The Alipur bomb case, which came to be known as the most famous controversy of the time. Many revolutionaries, including Aurobindo Ghosh, were suspected to have been engaged in illegal activities and sedition and were subsequently arrested. C.R. Das was renowned for his legal brilliance and his dedication to justice, particularly during India's independence movement. Apart from successfully defending Aurobindo Ghosh in the Alipur bomb case, he played a significant role in many of the cases like Chittagong Armory raid case, non-cooperation movement trials, sedition cases. His dedication to justice and his ability to combine legal expertise with patriotism and most influential lawyers in Indian history because of his activities. He is known as Deshabandhu. And revolutionaries like Bhagat Singh, Sukhdev, and Rajguru were arrested on the charges of throwing bomb in the Central Assembly Hall. Asaf Ali, freedom fighter and prominent lawyer, defended the revolutionaries, but they were hanged on March 23rd, 1931. When three captured Indian National Army (INA) officers, Shah Namas Khan, Prem Kumar Sehgal, Gurbaksh Singh Dilan, were tried for treason at Red Fort, they were defended by Bulabai Desai, Asaf Ali, Kailashnath Kajju. The successful release of all three officers was a major accomplishment for the Indian attorneys. Similarly, there was a constitutional challenge in 1927, not about making of the Indian constitution itself. The challenge was made after Indians opposed the Simon Commission. Lord Birkenhead, then Secretary of State for India, in the House of Lords said, in quotes, let them, that is Indians, produce a constitution which carries behind it a fair measure of general agreement among the great people of India. Leaders of the national movement responded to the challenge by drafting the Nehru Report, and in 1928, the architect of the Nehru Report was Motilal Nehru. Of course, they conceived only dominion status within the status of under the British government. And after the cabinet mission in 1946, we have general elections, the establishment of the Constituent Assembly with Dr. Rajendra Prasad as chairman, a freedom fighter and lawyer. The Indian Constitution was drafted by Dr. Ambedkar, an eminent jurist and social activist. The Indian Union, during the partition, Sardar Patel served as the India's first Home Minister and Deputy Prime Minister and oversaw attempts to re-establish peace throughout the country while organizing aid for refugees in Delhi and Punjab. Because at the time of partition, once again, the lawyers played a major role in settling the disputes arising out of the partition. And Sardar Patel is the father of Indian Union. I already told you that India had different enclaves. So the dawn of freedom did not mean the unity of India. So with 560 princely states and territories of Kashmir and Goa were secured by the action of Sardar Patel. And in South, I would like to mention, I would be failing in my duty if I do not mention the name of Rajagopalachari, who was an ardent follower of Gandhiji. And when Gandhiji enacted the salt satyagraha in Gujarat, and same was enacted from Tiruchirappalli to Tanjavur, that is Vedaranyam, it is called Vedaranyam Salt March. And it was led by Rajaji Rajagopalachari. And again, he gave the Rajaji formula. A very unique personality, was practical in his way of thinking. And he was also the first Indian Governor General after independence in 1948. And the role of Vivo Chidambaram and Swadeshi Venture, the Swadeshi Steam Navigation Company, and as against the British Steam India Navigation Company, is legendary in its aspect. I think recently Venkatachalapati has come out with a book on Swadeshi Steam Navigation Company, and it really speaks volumes of VOC. We shortly call him as VOC. His role, and I don't think that his role has been very rightly documented and articulated in the pages of freedom movement in India, particularly the role of South India itself. But I must say, the book has done really justice to the role of VOC and Swadeshi, the Swadeshi venture, pitching the native capital against the European capital. And I must conclude because I think I am right. This is an inaugural address is only a tip of the iceberg. So I would like to conclude. In conclusion, I would like to say that lawyers held an incomparable position in the freedom struggle, and they were indispensable. They made a remarkable contribution to the pre-independence Indian society, the effects of which carried on even after independence. If I may add, the new age lawyers should take a leaf out of the history books and take inspiration from their predecessors and not restrict their ability to contribute to Indian society. I'm happy to inaugurate this two-day national conference, Legal Professionals in the Indian Freedom Struggle. I'm sure the ensuing proceedings will enrich the corpus of Indian national law. Thanks for the opportunity. Thank you.
Thank you so much, sir. Thank you so much for setting the context of why this conference is happening today and the research that has to be done inside the legal professionals of the nationalist struggle. And you've beautifully given us an overview of the nationalist struggle and highlighted points that we should keep in mind as well. So, with that, we're extremely grateful for all of the work that you've done in the history department and the research you've done into nationalism. We will move on to the keynote address, which will be given by Professor Mithi Mukherjee. She has a PhD from the University of Chicago. Her book, India in the Shadows of Empire, A Legal and Political History from 1774 to 1950. It was released in the year 2010. In this, she contends that the concept of justice as equity, as opposed to freedom, provided an ideological framework for the British Empire in India, and also this became the ground for anti-colonial representational politics under the Indian National Congress. This highlights the topic which she has chosen for her keynote address today, which is imperial justice and the rise of the anti-colonial lawyer as political representative in British India. We're extremely excited to invite Professor Mithi Mukherjee to now give her keynote address.
Thank you very much. Thank you to all of you for coming. And it's a great honor and a great pleasure to be with you here today. This is a terrific conference, and a very big thank you to Dr. K. Dipanjan and Dr. P. Kumar and the joint organizing committee of the Tamil Nadu National Law University and the School of Social Sciences at the VIT AP University, Amravati, for inviting me. I'm very grateful for your very kind introduction. So I have for you a PowerPoint. If you'll give me a second, I'll just put that up. So yes, the title of my paper is Imperial Justice and the Rise of the Anticolonial Lawyer as Political Representative in British India. Let me start with the report of the Third Indian National Congress held in 1887 in Madras. As you're all aware, and as Professor Rajendran pointed out, the Indian National Congress was founded in 1885 as the first representative body for Indians in colonial India. Included in the appendix of this report is a very important pamphlet called a catechism, a pedagogical text written with the specific purpose of instructing the Indian masses on the idea and practice of representation. This pedagogy of representation comes in the form of a conversation between Maulavi Fariduddin, an advocate, and Rambakhsh, a villager of Kambaktpur. It begins with Rambakhsh's question to the advocate, and he says, Maulavi Saab, there's a great talk nowadays of representation and representative institution. But what does it all mean? I'm pronouncing it like this because that's how it's written. In response to this inarticulate villager, who presumably embodies the masses of India, stuttering out the critical words with such hesitation and difficulty, the advocate, rather than propose a definition of representation, draws a familiar image before him. Don't you remember last year when you and Matadin and Ram Prasad and some 30 others of you had cases against Raja Harbans Rai? And all the cases were quite alike, and you knew well about the matter and had the best head of the lot. They all chose you and sent you in to me, to the Sadr, to explain all the cases and get me to put in petitions for them as well as for yourself. Well, that is representation, and you were the representative. What is striking about this attempt to convey the idea of representation through an everyday experience was its essential grounding in the law court or the Sadar Adalat and its vital connection to the person of the advocate. In the Congress's political pedagogy, the idea and practice of representation was presented as fundamentally juridical, linked to the practice of petitioning one's complaints and grievances in a court of law. Moreover, in this chain of representation, the advocate himself played the indispensable role of mediating between the villagers and the judge. In other words, the practice of representation, as the Congress of 1887 portrayed it, hinged on the existence of the law court, the paradigmatic representative institution, and the persona of the lawyer, the quintessential representative figure in colonial India. Thus, unlike in the British House of Commons, the claim for representation by the Congress was not grounded on the idea of popular sovereignty or general will, nor was it ever demanded that legislation for India would have to reflect the real interests of the people, or that the executive committee would have to be accountable to the popular will. Rather, the demand was only that the representatives of the people be heard in the Legislative Council as lawyers, articulating genuine popular grievances as mediators between the government and the people. The final judgment on the public good would continue to rest with the executive. It is important to keep in mind that the discourse of the Congress was addressed in the immediate colonial context of the Viceroy's Legislative Council. By the Council Act of 1861, this institution had been made into a despotic body, in which the colonial executive exercised absolute authority without any sense of accountability. What the Congress was pleading for was that the Council adopt the discursive structure of a court of law, like its predecessor, the Legislative Council of 1853, where judges had played such an important role in making the executive accountable. Let's take another example, this time a speech by Madan Mohan Malviya, a prominent lawyer and leader of the Indian National Congress in 1906, pleading for elected representation in the Indian Legislative Council. And this is what Malviya says. He says, in the reformed council, the government will exactly be what they now are, the final arbiter of all questions that may be brought before the council. In other words, they will occupy the position of a judge in deciding all questions affecting our purses, our character, in fact, our whole being. The sole privilege that we are asking for is to be allowed to choose our own counsel to represent our cases and conditions before them. The privilege of selecting one's own counsel is not denied even to the most abandoned criminals under British rule. Why then should it be denied to the loyal and intelligent subjects of Her Gracious Majesty? Here, Malviya is pleading for popular elections to the Viceroy's Legislative Council, which, by the Council Act of 1861, had been made into a despotic body in which the colonial executive exercised absolute authority without any sense of accountability. Given that the practice of choosing one's representative to the legislative body is the very bedrock of democracy, he is pleading for freedom. However, for Malviya, freedom is not a right, but a privilege, a gift from Her Gracious Majesty. Also here too, as in the previous example, the Legislative Council is being reconfigured in the image of the law court. What is assumed in Malviya's statement is a theory of political and legislative sovereignty. A government becomes the sovereign as a judge, the final arbiter. Having set up the image of a court of law, Malviya now argues that just as a judge would neither select the lawyers for the plaintiff and the defendant, so also the British government as judge must also allow the people of India to choose their own representatives. Ultimately, he says, the government as judge would determine not just all questions affecting our purses, but also our character, our whole being. The emphasis on the whole being of the colonized points to the creation of a new imperial subjectivity. It is because the early Congress understood freedom as a privilege, a gift of the empire, that it pursued it through a politics of pleading and petitioning. In this context, the very notion of resistance was alien to its discourse. Madan Mohan Malviya's speech can be explained as following the discursive structure of a lawyer's speech in a court of law. Malviya, however, was not the only lawyer in the Indian National Congress in 1887. In fact, the Congress from its very inception was dominated by lawyers, barristers, and judges, many of whom, as Dr. Rajendran pointed out, were trained in London. The trend among Indian lawyers of traveling to England to acquire legal training as barristers and advocates in the Inns of Court in London started with the philanthropy of Rustamji Jamshedji Jijaboy, a wealthy Parsi leader in Bombay who sponsored 5 Indians to acquire training as barristers in England. Some of the men sponsored by Jijaboy, like Umesh Chandra Banerjee and Feroz Shah Mehta, became leading barristers in India on their return and even rose to the position of presidents of the Indian National Congress. Of the group of 9 men who formed the central leadership in the early Congress, as many as 6, Feroz Shah Mehta, Badruddin Tyabji, W.C. Banerjee, Manmohan Ghosh, Lal Mohan Ghosh, and Ananda Mohan Bose were lawyers, and 2, Surendranath Banerjee and Ramesh Chandra Dutt, had received legal training. 11 of the 16 Indian presidents of the Indian National Congress between 1885 and 1909 were lawyers. Even among the delegates who were not in leadership positions, over 1/3 in the period 1885 to 1914 were lawyers. The dominance of lawyers in the anti-colonial movement continued with such prominent names as Mohandas Gandhi, Chittaranjan Das, Muhammad Ali Jinnah, Bhulabhai Desai, Radha Vinod Pal, B.R. Ambedkar, Jawaharlal Nehru. As you see in the slide before you, the number of pictures, but if I had to give the pictures of all the lawyers, that would just fill up pages and pages of this. So I just selected a few. Historians who have studied the central role of lawyers in the Indian anti-colonial movement have done so primarily through the lens of social history. Some of the prominent historians who threw light on the role of lawyers in the Indian National Congress early on belonged to the Cambridge School. Anil Seal, for example, attributed the dominant role of lawyers to patron-client relationships that formed in this period both at the local and national levels. In his opinion, the Congress was a body constituted by men who pursued narrow local parochial ends and selfish advancement of their own careers, rather than any lofty goals like nationalism. John Maclean stressed the rapid expansion and growth of the legal profession in the 19th century, specifically as the result of a rise of litigation in the presidency towns of Calcutta, Bombay, and Madras, and also in provincial towns. He emphasized the spread of legal education and the rise of universities devoted to the study of law in the 19th century that opened up the legal profession to a large number of English-educated middle class who gained power and influence over their countrymen in every district. While studies on the social origins of professional groups like lawyers who participated in the Indian National Congress. Okay, are we good? Can you hear me?
Yes, we can hear.
Okay, sorry. I heard some other voice there. Sorry about that. While studies on the social origins of professional groups like lawyers who participated in the Indian National Congress do throw valuable light on the nature of the party and its politics, it is inadequate to assume motivations of Congress leaders based on class or personal interests alone. To explain the dominance of the lawyer in the anti-colonial movement, one has to turn to a deeper study of the nature of the British Empire in India and the discourse of imperial justice that opened up the space for lawyers to become the quintessential political representative. My argument is that it was not because these men were lawyers with personal connections at the local and national level that they came to participate in such large numbers in national politics. Rather, as I demonstrated through the examples of speeches above, the pamphlet that I talked about in the beginning and then Malviya's speech, it was because representational politics itself was grounded in a juridico-epistemological field and structured by the methodologies, procedures, and practices of the British law court that a space was created within which lawyers could emerge as the modern political representatives. The unity of the Indian National Congress derives specifically from its grounding in this juridical framework. Its discourse was not based on the idea of the representative will or freedom of the people, as you find in, for example, Rousseau, right? Nor indeed was it addressed to the people of India. Rather, it was grounded in the category of imperial justice as equity and addressed to the Queen of England as impartial judge. Indeed, it was in the Congress's faith in the inherent justice of the empire, emanating from the benevolence and mercy of the monarch, the British monarch, rather than in the universality of law that its opposition to colonialism was grounded. Let's go back 100 years. The year is 1788. The House of Lords is overflowing with large crowds who have come to witness one of the most important trials of the 18th century in England, the trial of Warren Hastings. Hastings, first Governor General of the East India Company in India from 1772 to 1785, is on the dock being impeached for high crimes and misdemeanors. Along with charges of corruption, the use of political power for extorting bribes from native rulers of India, abuse of judicial authority, despotism, and arbitrary rule, Hastings is being tried specifically for illegally occupying territory in India by launching aggressive, offensive, and criminal wars against native rulers, treaty violations, and for open violence against native rulers and the people of India. Leading the prosecution is Edmund Burke. You can see him in the picture standing up with his arm out. He's Edmund Burke, the political philosopher and parliamentarian. The immediate historical context is the loss of the American colonies, in which the British Parliament had gone to war with the American colonies to assert its rights to exercise parliamentary sovereignty over America. So if as you know from the history of the American Revolution, this idea of legislative sovereignty, right, the right to represent yourself or to represent themselves was a very important part of the American War of Independence. In the end, as historian J.G.A. Pocock has contended, Britain preferred to lose her American provinces rather than modify her political institutions to accommodate them. For to give up on the unity of the Crown and Parliament was to give up on the idea and practice of liberty itself, which in British history had come to be indelibly tied to the existence of this institution. It was in the impeachment trial of Warren Hastings that Burke sought to convince the political establishment in Britain that the only way to preserve empire in India without giving up on liberty at home, and at the same time ensuring that the rights of the colonized were preserved, would be to foreground the juridical dimension of the existing institutions of parliament with respect to empire, and to create a confederation tied not by legislative subordination to the House of Commons, but by a judicial attachment to the Crown and the House of Lords. Whereas the American war was fought in the name of the sovereignty of Parliament, Burke sought to preempt such a war in India through a judicial reconfiguration of British political institutions and the construction of a discourse of imperial justice in terms of natural law. Burke spent 14 years developing a comprehensive judicial discourse to situate India in the larger framework of the British Empire. He proposed to anticipate Indians' resistance to the East India Company's government by introducing a system of justice that would arbitrate impartially and supranationally between the colonial state and the colonized society. So Burke, the legislator in the case of America, appeared in the persona of a lawyer to articulate the new imperial discourse of justice, where the people of India emerged not as a people asserting their freedom, but as supplicants to justice at the bar of the House of Lords. As you can see in the speech here, he says, exiled and undone princes, extensive tribes, suffering nations, infinite descriptions of men, different in language, in manners, and in rights, men separated by every barrier of nature from you, by the providence of God are blended in one common cause, and now become supplicants at your bar. So you can see here again, there's this idea of the court of law in which Indians are supplicants for justice. With the people of India acting as plaintiff and the East India Company's government as the defendant, the House of Lords, acting in its judicial capacity under the Crown, would provide the supranational impartial arbiter, able to address the grievances of the colonized society against the colonizing state. In this trial, we see the clash of two discourses, what I call the colonial, that was articulated by Warren Hastings in his defense, where he justified territorial conquest, power, violence, domination, and subjugation of the colonized. And on the other, what I call the imperial, that was articulated by Edmund Burke, the prosecutor. England, which stressed, this discourse of the imperial stressed justice as equity for the colonized, represented by the figure of the imperial monarch as the arbiter of conflicts between the British administration and the Indian people, and between different groups of people. The connection that Burke made between the discourse of empire and the discourse of justice came to permanently structure British rule in India and the anti-colonial movement that emerged in the 19th century. The British engagement in India, with India, I contend, was not a homogeneous phenomenon, but rather characterized by these two competing but also collaborating political discourses of the colonial, which was the major discourse, and the imperial. The clash of these two was reflected in India in the conflict between the Supreme Court, established in India in 1774 under the authority of the Crown and Parliament, and the government of the East India Company. During the late 18th and first half of the 19th centuries, this autonomous court served as an external check on the executive power of the East India Company. Its distinct purpose was to hold the company's government legally accountable for its policies and actions, with the final appeal lying in the Privy Council in England. With its well-trained barristers and judges, it provided the sole legitimate arena for the presentation of grievances against the East India Company's administration. It was in this court that the conflict between the colonial and the imperial unfolded as a grand spectacle before the people of India, and in which colonial power was subject to public scrutiny and forced to answer to imperial justice. By the Charter Act of 1833, Parliament recognized the East India Company's sovereign legislative authority and made the Supreme Court hitherto autonomous, subordinate to the Governor General in Council, the head of the Government of India. In the absence of a legislature, the Supreme Court was the predominant lawmaking body, and decisions by the court played a central role in bringing about social change in India in the early 19th century. As Henry Maine commented in 1876, in the absence of formal legislation, the true revolutionary agent in India has been neither the executive government nor the legislature, but the court of justice, without which the existence of British rule could hardly be conceived. The need to reconcile differences between the Supreme Court and the Governor General in Council led in 1853 to the creation of a legislative council in the image of a British law court. It applied judicial categories, followed judicial procedure, and included among its members the Chief Justice of the Supreme Court, another judge, and a barrister. So in 1857, as we all know, North India broke out into a revolt that was unprecedented in its ferocity. Although it was suppressed, it shook the foundations of British rule and led to the reconfiguration of the colonial state, which had been dominated by the discourse of violence and oppression. The East India Company's rule came to an end, and power was transferred to the Queen in Parliament. Falling back on Edmund Burke, the Queen's proclamation promised justice and equity to all her colonized subjects with the aim of preventing another rebellion. So here's a picture of the Calcutta High Court. One of the most important changes that was instituted was the end of two separate systems of courts and the creation of a uniform judiciary that incorporated the earlier Supreme Courts and the East India Company's courts. The new high courts established in 1862 in the main cities in India, including Calcutta, Bombay, and Madras, were placed in a hierarchy of courts, with lower courts now accountable to higher courts and the ultimate judicial authority lying in the Privy Council in London. In contrast to the earlier system, in which only exceptional cases against the company's government were brought to the Supreme Court, in this system, such challenges would be a regular affair. As the legislator J.F. Stephens stated, ever since the earliest regulations of Lord Cornwallis, the liability of the government of India to be sued in its own courts, like private persons, has not only been established, but as every Indian knows, though English readers may not be aware, it has been continually carried into practical effect. The means by which the poorest peasant in India can obtain against the government of India a remedy for any wrong he may have sustained from it are far simpler, more clear, more effectual than the means by which the richest and most influential men in England can get a remedy against the government of England. With the rise to prominence of Mahatma Gandhi, a political breakthrough occurred in the demand for national independence. I'm sorry, just give me 1 second. Sorry, just 1 second. Yeah. Before I come to Gandhi, the representational politics of the Indian National Congress can be understood as firmly lodged within this particular juridical framework that I've been discussing. And this explains why its mode of politics took the form of pleading and petitioning by a small group from the educated elite, led by the lawyer, the quintessential political representative at the time. Burke's speeches for the prosecution became one of the most important sources of inspiration for the Indian National Congress as it searched for a way to articulate its demands on the colonial state. Many members of the Congress memorized the speeches and often of Edmund Burke and often recited them at political meetings. The government of India, supposing that Burke's works, which were popular, encouraged disloyalty, banned them from the University of Calcutta. All petitions from the Congress took on the nature of pleas, addressed ultimately to the magnanimity, benevolence, and conscience of the monarch. Even as the Congress took on the persona of the lawyer, it made no claims to absolute rights of subjects based on the universality of law. Rather, it trusted in the discretion of the monarch as a judge, who, keeping in mind the particularities of their case, would render, it was hoped, an equitable justice between the colonial administration and the people of India. This explains why the discourse of justice as equity that had helped to launch Congress's politics of anti-colonialism also constrained them. Unable to envision national independence outside the empire, the Congress failed to articulate a discourse of freedom. The goal of home rule that the Congress articulated in its most radical phase before Mohandas Gandhi assumed the political leadership was not the same as the demand for national freedom, because home rule, insofar as it sought legislative powers within the empire, assumed the ultimate sovereignty of the emperor. Almost, as I pointed out earlier, almost all of the most eminent leaders of the Congress were lawyers, including Rana De Tilak, Chittaranjan Das, Gandhi, Jinnah, and Ambedkar, as also Pandit Nehru. So with the rise to prominence of Mahatma Gandhi, a political breakthrough occurred in the form of a demand for national independence rather than imperial justice, and in the launching of a mass movement to rival the politics of pleading and petitioning. Gandhi launched the non-violent non-cooperation movement with a call for the boycott of every British law court and with a ban on practicing lawyers from leading the struggle for national independence. Gandhi, who asserted that the British colonial state had relied on the law courts to perpetuate its rule in India, predicted that allowing the lawyers who dominated Congress to continue to lead the movement for independence would be nothing short of committing national suicide. In 1922, when Gandhi was tried for sedition for leading the non-cooperation movement, he publicly repudiated the discourse of imperial justice by pleading guilty on all charges of sedition. Unafraid of any punishment, he asserted The government established by law in British India was carried on for the exploitation of the Indian masses and for prolonging her servitude. I hold it to be a virtue to be disaffected towards a government which in its totality has done more harm to India than any previous system. The Gandhian discourse of freedom was distinguishable from the Congress's in that it was grounded in Indian discourses of spiritual freedom, which bore little relation to Western discourses of political legislative freedom, grounded in the idea of a state on the one hand and ideas of property and individual rights on the other. Thus, even as the Gandhian movement sought to free India from British colonial rule, it did not envision taking responsibility for running the government of post-colonial India. In other words, Gandhi did not construct a legislative discourse of governance coupled with freedom. Thus, after independence, once again, this discourse of justice came into prominence, and lawyers have played a very, very important role after independence once again. Thank you very much.
Thank you so much, ma'am. That was very enlightening on the take that you have on why the legal representatives finally came to the position of representing the Indians in the nationalist struggle as well. So, thank you so much for that. And we are grateful again for the work that you've done that has added to our conference as well. So, with that, we have come to the end of the inaugural session. Dr. Priyanka Ghosh, the Dean in charge of VIT AP School of Social Sciences of VIT AP University, will now give us the vote of thanks.
Thank you. Good morning to one and all present here. It is my honor and privilege to deliver the vote of thanks at the inaugural session of the two-day National Conference on Legal Professionals in the Indian Freedom Struggle, organized by the Legal Center for History of India, Tamil Nadu, National Law University, in collaboration with the VIT AP School of Social Sciences and Humanities, Amravati, Andhra Pradesh. First and foremost, I extend my heartfelt gratitude to the Honorable Vice Chancellor of Tamil Nadu National Law University, Professor V. Nagaraj, and the Honorable Registrar, Professor Dr. S.M. Balakrishnan, for providing us with this opportunity to collaborate and contribute to this conference. I'm also deeply grateful to the Vice Chancellor of VIT AP, Dr. S.V. Kotareddy, for gracing this august occasion with his presence. Thank you, sir, for your unwavering support and guidance. A special word of thanks to Professor N. Rajendran, former Vice Chancellor of Alagappa University, Tamil Nadu, for honoring us with his esteemed presence at the inaugural session. I would like to express my sincere appreciation to Professor Mithi Mukherjee, Associate Professor of History at the University of Colorado Boulder, USA, for delivering the keynote address and enriching the session with her valuable perspectives. Finally, I extend my deepest thanks to both conveners, Dr. P. Kumar, Assistant Professor of History, Legal Center for History of South India, TNNLU, Tiruchirappalli, Tamil Nadu, and Dr. K. Dipanjan, Assistant Professor of History from VIT AP University, for their tireless efforts, dedication, and meticulous planning in organizing this conference. I thank all faculty members, research scholars, professionals, and students for joining today and making the inaugural session a grand success. Thank you all.
Thank you so much, ma'am. So, with that, we have come to the end of our inaugural ceremony for the two-day national conference. We will have our tea break now, and we will rejoin for the special panel on law, lawyers, and nationalism in India, which will begin at 11:10. So please do join the link at 11:10. There is a new link for the same. And please do join all of our sessions for the next 2 days as well. Thank you so much to everyone.
Thank you.
Thank you, everyone. Thank you, Professor Mukherjee.